Hi, everyone. Harry here to talk about the really deplorable, probably unconstitutional conditions that the Trump administration is imposing on ICE detainees. This is in Manhattan, but reports are similar around the country. And a legal order to tell them to stop and give with real particulars the kinds of minimal requirements that they need to immediately put into effect. All right, this is Judge Lewis Kaplan. He has been a burr in the saddle of Trump during his time out of office and some of the criminal and other actions. And he was the person who received a lawsuit that was filed by a particular immigrant who is being held in a cell temporarily in Manhattan, but who also asked the judge, and the judge agreed to recognize a class of persons that are similarly situated, basically, for now anyway, the folks who are in this holding area in Manhattan. Okay, so he holds a hearing, does Kaplan, yesterday, and he enters an order at the end of the day. That's just a temporary order. Then he's going to take up, we're, learning more and more how this tends to work, the motion for a longer term injunction and the permanent certification of a class action. And that would potentially provide even more sweeping protection. But we get into, you're going to hear criticism, likely, by the administration of the supposed micromanagement of the judge, because the order here has a lot of particulars about what they need to do as far as how much space and the like. And you're going to hear the administration complain, we are the ones who have to figure this out. We know how much space is available overall. We know how much, we have to deprive every different detainee and the like. And the argument in response, now made by the putative class of Sergio Mercado and others, the case is Mercado versus our old DHS secretary, Kristi Noem. It's going to be, you're the one who forced us, government, into this position where we're giving you such particulars. But the complaint here that Kaplan received complaint is allegations, as you know, it's not evidence, and that's what future proceedings will be about, but just a horrific set of allegations about just, nasty, rotted, stinky, overcrowded kinds of housing. And certainly that dovetails with similar accounts we've heard from people around the country that they're, remember this really kind of intersects with the efforts that ICE has tried to foil of members of Congress to give unannounced inspections in order to, in their oversight capacities, be sure that ICE is actually housing folks humanely. And ultimately, that's an issue for Congress to decide, or that's certainly what the law seems to provide. You'll see pushback on even that from Trump. But Kaplan does what's called a temporary restraining order. It's not supposed to last that long. In theory, it shouldn't be overturned by an appellate court, but he should move promptly to consider an injunction. But here's what it provides in the interim. So we're talking about a particular center. Oh, and by the way, going back to that whole dynamic with ICE trying to prevent the unannounced visits, they actually have said we need a week notice, and also if we house people, because we have to, in our home offices, administrative offices, you can't come in there at all. And if that's what this is, you can see now that they want it to be a kind of a law-free spot. But anyway, this is at 26 Federal Plaza in New York, and he just really goes through chapter and verse. You got to have 50 square feet for each inmate. You got to have bedding for each one held overnight. You've got to clean the places thoroughly. You've got to give them soap and towels and toilet paper and the like. None of this is a specific like Supreme Court doctrine of, if you don't give towels, you are engaging in cruel and unusual punishment, or since they'll say this isn't punishment, it's just regulation of detainees, that you're engaging in unlawful conduct. And that's what you'll hear back, I think, when the administration runs to the Second Circuit. On the other hand, they have supplied such, substandard kind of situation that it leads Kaplan to say very specific things like this. So that's the first is make this, not to have the standards of homeless shelter or whatever, not completely disgusting. And then there's a whole question of being able to consult with their lawyers. So he also orders that there be certain telephone lines that are dedicated, that the calls be confidential, that they do the calls pretty promptly after people are gathered up and put in this holding room and the like. So, it is noteworthy on the one hand that it's such a sort of specific kind of order. And we've seen this in other areas. I think of the jail overcrowding, where you have certain district courts issue very particular orders, but those, of course, are in response to very particular complaints, where people are coming in and testifying, we don't have soap. They never clean the place. We have to, be huddled like sardines. And that's what district courts do. They, hold, but they have to hold on the basis of their lawful authority. They're not there to make the law, but they are there to apply the law of some sort of, minimal level of humane comfort, and certainly minimal level, which this administration seems to be indifferent about denying, of communication with counsel, that being, a basic tenet of all these things. We've seen previous opinions, Boasberg up to the Supreme Court, etc., that have made clear that you have to have due process rights, and that means you have to be able to consult with a lawyer. So Kaplan imposes all those things. Be prepared for a pushback to the higher court from the administration, probably on an emergency footing, saying, this is overly particularized. This is a judge who is now trying to do our job for us, rather than simply be sure that the minimal standards are complied with. Of course, the complaint he has shows that it's a far cry from that, and it's certainly not unusual for, in that setting, district court judges to be quite specific, in terms of how much space and the like, but that it also will be likely to provoke the kind of pushback from the administration saying, he's weeding in our garden. So we'll see what happens. This is not, in theory, the kind of order that should be appealed. Rather, he should move quickly to the injunction hearing, and that would be the thing that's appealed. We saw this just last week in the Boasberg case, but that's also a sort of proposition of law that some courts have kind of honored in the breach, and they go and look at it anyway. The Second Circuit, pretty progressive court, wouldn't expect them offhand to be slapping down Kaplan, but that's the area that we now occupy, the difference between finding this doesn't cut it and ordering up with real specificity specific provisions about how clean, how big, how many phone lines, and the like. So that's what we should keep our eye on. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.